Hi everyone, welcome back. Today I want to cover a little bit of studying of the words that we're going to deal with that we have to understand. We're in the second phase. The first phase was the confidence that we're the Chief Justice, that we are in control of the court, and we are the ones that have to take the action. And once we know that that's our mission and we have to do it, then we have to learn, understand the different words and what they mean and the rules and the procedures. So by now I'm sure you got your Black's Law Dictionary and you're tearing it up, because you better be looking up those words, because that's the firepower. Those are the tools we're going to use. So one of the words I want to talk about today is presumption. This is what all the courts operate under, this is what the agencies operate under, and this is what pretty much everyone operates under in almost every field today. So I want to give a definition here out of Black's Law. I'm going to skip down to the second one, and a presumption is an assumption of fact that the law requires to be made from another fact or group of facts found or otherwise established in the action. Okay, like a presumption is not evidence. A presumption is either conclusive or rebuttable. Every rebuttable presumption is either A, presumption affecting the burden of producing evidence, or B, a presumption affecting the burden of proof. Okay, so we're going to have to dissect that here. Presumption is either a presumption affecting the burden of producing evidence. Okay, so whenever a party, we know that when a party brings an accusation, they have the burden of proof. But the burden of producing the evidence is not necessarily on the moving party, because they are operating by a presumption. Okay, and another thing we want to know and understand is that every presumption of law is rebuttable. So a presumption is an assumption. So let's take, for example, you get stopped and you get issued a traffic citation. The officer writes down that you were driving while you were intoxicated. He pulls out his little device, he gives you a breath test, and he produces some evidence that you're intoxicated. But what about the driving? Did he prove you were driving? This is the question, because he's really operating under a presumption. And the presumption is that you are driving. And if you don't rebut that presumption, then that will be the foundation of the charge. And you've admitted it by not rebutting the presumption, because every presumption of law is rebuttable. How would you rebut the presumption that you are driving? Okay, one way would be to tell him, I'm not driving. I'm rebutting your presumption. Therefore, because I've rebutted your presumption, the burden of producing the evidence is on you. So now he would have to produce the evidence that you are driving. Okay, so you have to know what that evidence would be, what he needs to produce in order to show that you are driving. Okay, so it's just a very simple word game. But it starts with the presumption on his part. In all civil actions and proceedings not otherwise provided by an act of Congress or by federal rules of evidence, a presumption imposes on the party against whom it is directed the burden of going forward with evidence to rebut or meet the presumption, but does not shift to such a party the burden of proof in the sense of the risk of non-persuasion. which remains throughout the trial upon the party whom it was originally cast. So this is the federal rules of evidence. See, we understand how evidence has to be produced, and that the burden of proving the case is different than the burden of producing the evidence. And once a presumption is met, the burden of producing the evidence shifts to the individual party who raised the presumption. And that would be the officer. His presumption was you were driving, and if you meet that, then he has to then produce the evidence. Okay, and a good way to have him do that might be to have a motion to dismiss calendared on the law and motions calendar with subpoena ducis tecum to bring in that officer with the documentation of the evidence that you were driving. The evidence that he had that authority to stop you and look at your paperwork. Now see, the reason why the agent asks you for your information and he doesn't have a warrant is because he's acting under the presumption that you're driving, and if you're driving by a privilege, then you've waived your right to a warrant. And this is the presumption they're operating under to stop people on the highway as they're driving. And they use that as a method to presume that everyone's under their authority. So you're going to find out when you watch these agents operate, they are going to presume you have no constitutional rights. They're going to presume that they are in total control of you and that you have to do everything they say. Because that's not the way it is. It's presumption. And if you operate with them in the presumption, then you fail to rebut the presumption, and they're not required to prove or bring any evidence to show that you're under the presumption because you've gone along with it voluntarily. And that's why they say everything is voluntary in America. You pay your taxes because you voluntarily go by the presumption that you had income. So you rebut it. So if you don't know what income is, you're going to have to go look it up in the dictionary, and you're going to have to know what income means in administrative law, what it means under the law of presumption. What does driving mean? What does the word dollar mean? These three areas are the basis for the presumptions that government controls each one of us, because we are the ones in control. But presumptively, they're in control. If you don't meet the presumption, you're agreeing with them. This is the beginning and this is the end. So this presumption is being presented in the free world. It's a constitutional concept. See, it's not only administrative but judicial. So let's see here, the presumption in the first one is an inference in favor of a particular fact. A presumption is a rule of law, statutory or judicial, by which finding of a basic fact gives rise to existence of presumed fact until presumption is rebutted. The officer finds you were driving. You failed to rebut, then you agree with the presumption. As soon as you meet the presumption, the burden of producing evidence shifts to the agent, and now you're in control in your constitutional court, which you just flipped his agency court. They're the same. Okay, so we're going to talk about the agency and the administrative remedy next time. So thanks for being here, and we'll talk to you soon.